of the North Warwickshire Borough Council and the Secretary of State for Transport and another.
Yes, Mr. Howell.
Good morning, my lord and my lady. This is an appeal against the judgment of Mr. Justice Dove, as he then was. And now I introduce myself. I'm supported by Kate Ollie of Council, who sits behind me, for the Secretaries of State, Mr. Strawn and Miss Hutton, and for the interested party, HS2, Mr. Corner and Miss Lean. Yes, I wonder whether the first thing I should do is just to cover off one or two administrative matters.
Yes.
There's been some ping pong on documents, so it's important to be clear that we've all got the same pack. The first document, not in any particular order, is Schedule 1.
Yes.
Your Lordship will have noticed that the bundle, the authorities bundle at tab 3, contained only the first page. And I think it's sensible, indeed I think it's necessary, for the court to have the whole schedule in order that the court can see and peruse and consider the works.
Yes.
So we have a copy of that.
Yes, please.
To distribute. The second document is the statutory guidance to Schedule 17. That wasn't in my copy at tab 5 of the authorities bundle, and it's right that it should have been included. We have a copy of that as well. A further curiosity in the bundle is that in the supplementary bundle at tab 12, there's the first page of an information paper, number 32.
Could you give the page reference, please? I don't think we have tabs. We don't. So that was page
117, I think.
Yes.
It is, yes.
Thank you.
Thank you.
If you're going to remedy all these defects,
Yes, I'm going to hand in a pack.
well, why don't you hand them in and then you can take us through them and we can
Very
them
happy to
into
do
our
that.
bundles. That's
Yes.
your
There's only
design.
one further document which has been requested of us, which is to provide a copy of the skeleton on the notice of appeal.
Yes,
Got
we've
that
got
We
it.
can hand that up as well.
We've got
You
it.
do.
Yes.
I'm grateful.
Right. Tell us again where to put
Yes,
each of
there should be a copy of Schedule 1 to the Act, which is the full text of the scheduled works. There should be a copy of the statutory guidance to Schedule 17, and there should be a full copy of information paper number 32 to be inserted at page 117. And there should also be a copy of the skeleton on the notice of appeal.
Anyone's got a hole punch, that would be nice. Anyone's got a hole punch about their person, they are more.
A hole puncher. We'll see.
Don't worry, I'll do it at lunchtime.
My apologies.
One through one.
So the third document, a guide to the environmental statement, is that meant to go in front of 117?
I think, if I may, I've got the first page of the Guide to the Environmental Statement at tab 15, page 142.
Ah.
That's
And
it.
This looks like the same document.
That is it.
Okay.
Correct. It's
Thank you.
it should follow page 142.
But I can't
Not
find it anywhere
117.
at the moment because it hasn't been hell punched. But anyway, we have it.
We have it. I
Thank
do
you.
Well,
apologise.
I'm sorry to be very slow and stupid, but 142 has the same page as page 1 of this document. 143 is a plan, and whereas in the document you've just handed up, we go to page 2. So beyond page 1, they don't seem to be the same.
No, 143 is-
I'm just confused.
Right. My lord, in the index,
Yeah.
143 is the next document. So,
So it's not part of 142.
no, my
So
lord,
this would be the whole of or more of 142.
precisely, my lord.
Thank you. I've caught up.
And there's obviously a duplication of that front page.
Yes.
Right. Thank you.
Right.
Thank you very much. With the administrative matters covered, can I first indicate to you that I will be dealing with some introductory matters and ground 1, and Miss Ollie will follow with ground 2.
Yes.
So far as introductory matters are concerned, the first point is to give some observations about the rationale for maintaining the challenge. Ms. Levy, in her witness statement, has explained the rationale for bringing the challenge, and even at this stage, when, as you will hear no doubt, HS2 has built a large part of the amended scheme, there
When you
remains...
say that, there's the portal.
I don't believe the portal
But
is
when
yet
you say
built.
this amended scheme, you're talking about the tunnel extension.
Yes, I am.
Okay.
Yes, I beg your pardon. Yeah.
No. Just want to be clear.
There remains, however, a need for clarity and legal certainty in relation to possibly the two main provisions in the Act, sections 1 and 2. There are three basic concerns. The first is that this case should not be taken to provide a precedent for undue latitude in the statute. The court will have noted what Miss Levy says about that and the prospect of further works under the Act and further acts similar to this, containing like or similar provisions. So the danger of the precedent, we would say, is something that needs to be addressed. The second basic concern centres on due process and fairness. In this case, specifically in relation to the treatment of the extension to the Bromford Tunnel, which has, in effect, we say, and I will explain, been treated as if it's already been consented, authorised under the Act. But those who would have wished to have said something about it were not given that opportunity. And the court will have read Miss Levy's comments about the scale of the change inherent in the extension. Her opinion, at least, that it couldn't have been reasonably anticipated through the bill process and the enactment in 2017. The third basic concern is a related one, which is to maintain public confidence in the system. And that is with reference to the extensive parliamentary process gone through over a number of years in order to focus the scheme in Section 1 and Schedule 1 in particular. It received, as Miss Levy points out, detailed scrutiny, such that it would, in her view, lead the ordinary man to conclude that he had a reasonable expectation of what was going to happen in terms of the form of the railway and the likely impact of the scheme in a particular locality. The court will also have read about what we would call the equivocal position of the interested party, HS2, about the interpretation and application of the provisions. And that itself provides an excellent reason for this court to scrutinise what is going on. And the court will note, and I believe this to be the case, that the application under the Transport and Works Act, which at the time of the High Court was pending, is still pending. Indeed, I'm instructed that an extension was sought to hold that matter in abeyance until the outcome of these proceedings.
Is that an application in relation to one of the three works, deleting the words viaduct?
Correct.
30 metres of viaduct?
Correct.
Okay.
The next point...
And instead of 30 metres of viaduct, there will be...
that is the extent of the... Well, it's to delete those words, but thereafter it raises a question as to what would be left in the schedule with the description of that particular part of the works not being on viaduct, not being on tunnel, but with the depths shown on the deposited plans in place.
But the application simply deletes those words, doesn't propose anything additional or instead in lieu. Okay, sorry, thank you.
Could you, Mr. Halvorton, could you tell me, for my education, I'm sure specialists know about this, if an application is made for a transport and works order, what happens? Assuming that it's not held back as pending, but once it happens,
well, once the application...
What's the procedure and how long does it take and who makes the decision?
The Department of Transport would make, in this case, the decision. How long it takes depends upon the nature of the application and the proposal. There's a provision for the application to be made and consideration to be given to it. It's a separate but well-established process that infrastructure provisions go through.
Is there does an inspector hold a hearing, or is it all done on paper or by email?
It can be done, I understand, I think it can be done on paper, but it need not be. It could be referred and decided by an inspector.
Decided by an inspector, or does he report to the Secretary of State?
Or the Secretary of State, yes.
Yes.
A further point when just considering and have in mind the rationale and the importance of this decision is, of course, to recall that the Secretaries of State themselves accepted jurisdiction of the application under Schedule 17 for approval of the plans and specifications on the basis that it raised important or novel issues of development control and or legal difficulties. And of course, the last point to note is neither the respondents nor the interested party take the view that the challenge is either academic or in some other way not required. There's a tacit acknowledgement that the issues arising need to be determined by this court. The second matter I wanted to refer to by way of introduction is just some observations on the nature and scale of the changes to the works. And I'm here talking about the Bromford Tunnel Extension and the Bromford Tunnel Extension Portal. Both witnesses, Ms. Levy and Mr. Gilfedder, provide some explanation, and I don't wish to take the court to any particular passage, but seek only to highlight the following things as a demonstration, I hope convincing, of the significant changes that were proposed. Completely different from the original proposed scheme by any measure. Of course, significant changes at the Birmingham end and an extended tunnel of about 3.1 kilometres. Nothing turns on the precise figure. It is obviously a very significant change to the scheme instead of a viaduct. So far as the residents of Water Orton are concerned, the construction of this tunnel and the portal are significant by any measure. The tunnel itself, the relocated portal at the end of the tunnel where none was proposed before, that portal being proposed at the Birmingham end where the tunnel was originally planned to come to the surface. The portal, approximately 90 metres long and over 30 metres wide. But more than this, and significantly, more and larger compound areas for works. And Miss Levy spends some time in her witness statement explaining these with reference to plans and photographs which the
Well, I tried looking at the photograph. I'm afraid I didn't grasp which was the additional compound and as opposed to the original one, if we need to know. But I didn't find it very clear. And is there actually this all arises out of 3 works in Schedule 1. Is there a plan which, in very simple terms, just show you where the 3 works are? 157, 200 and 203. If not, could we have one during the course of the hearing? So it just makes it easier for us to write our judgments afterwards.
Yes, can I try and help?
Yeah.
And if I fail,
Okay.
somebody in the room will provide some further help. The first tab to look at is tab 18
Thank you.
on page 159. And this is a set
In
of...
the supplemental bundle.
in the supplementary bundle. Page 149. The other document that the court might find helpful to look at the same time is a document, I believe, produced by Mr. Gilfedder. It's in the supplementary bundle at tab 16, page 143.
We don't have tabs in it.
Page 143
143.
of the supplementary bundle.
Yes.
So that, at least in my copy, being in black and white, is not easy to define all the differences. But one can see in the top, there's a picture of course, a large area, a large coverage of the line. To the west in Birmingham, the original proposed position of the portal and the Bromford Tunnel as it was then proposed.
They're at the left-hand edge of the diagram.
Correct.
Yeah. Bromford Tunnels and East Portal.
That's it. And then the viaduct is shown.
Then it went into a cut, is that right?
I think so, correct, yes.
Where does the viaduct?
And then it comes into the viaduct.
Oh, there it is, in the, just in between the two hole punches.
Yes,
River Tame Viaduct, is that
yes.
right? Sorry.
And then to the east, to the right-hand side of the page, there's an overbridge before the rail comes into cutting. With cutting and embankment shown further to the left-hand side, to the right-hand side of the page. Underneath that, there's a representation of the extension, which merely shows the extended tunnel and the portal now located at Water Orton to the east. But whilst helpful giving a very broad overview, it doesn't show all the changes. What Miss Levy has sought to do, and Mr. Gilfedder as well from his perspective, is set out in more detail some of the changes.
Could you give us the references, please? Either now or later.
Yes. The first reference is to... Can I give the references in the witness statements
yes,
at a further stage? Can I come back to you on that?
Yes, please. Thank you.
But I asked the court to look at...
Catching up with you, I'm trying to relate this to Mr. Justice Dove's judgment, paragraph 3, where he sets out the 3 works in Schedule 1. And as I understand it, work number 200 is east of 203, and 157, I think, is east. Yeah. It's not very easy to follow, actually, particularly without a plan. So what you're showing us at page 143 is the tunnel as previously proposed coming in at the western edge, and that would have been part of work 203, I think, I hope. Showing my failure to understand this. And then the change that's portrayed between the top diagram and the bottom diagram affects work number 200, and possibly even at the eastern end 157. But I see some nodding. So
that is correct.
I've broadly speaking got there, have I?
Yes, well, more than broadly. That is it in a nutshell. If it helps further, just to remind the court that Your Lordship has the parliamentary plans, the deposited plans, in the supplementary bundle.
Yeah. I did point out these are not easy to scale to read.
No. If your lordship would like what I have,
What do you have?
I have an A3 copy of these plans,
Yes,
which
not
makes it a
too- in
bit
other words,
easy.
not too big. Legible, but
It
not
makes
too
it
big.
legible.
Yeah, thank you. That would, in case something arises after the hearing.
Of course, we'll undertake to provide those.
Thank you.
I haven't seen those A3 coloured copies, but because I have the same difficulty, I asked my solicitors for A3 coloured up copies of the plans, the parliamentary plans in tab 35, with the key on each page. If
Well, it's
they
the
need
key you can't
explaining-
read.
Pardon?
It's the key you can't read.
No, I agree. The key is, for me, was set out on each page,
Yeah.
and I found it helpful. If it needs explaining, I'm very happy for those copies to be produced.
Well, could it be?
If they need explaining, I'll ask.
There's a danger of having too many.
Because I'm half colourblind.
Could it just not be agreed between council?
I'm sure we can.
Yeah.
Yes, thank you.
Thank you. But I'm encouraged to know at least I was on the right track. Sorry.
Thank you. So we'll provide A3 copies and include the
It
legend.
should be agreed.
Of course.
Yeah.
So looking at page 311, my lord, and trying to assist you, if not in detail for now, but as a guide to what you may wish to consider more carefully at a future time, that contains the deposit plans. And looking, these move from east to west. Okay.
Which is, I think, the way the written text works.
Yeah.
Yeah. Confused.
So the first page is looking at Water Orton, and what we see is
Which page?
311. And we can see from these deposit plans, at least on my deposit plan more clearly, that work number 3157
Yeah.
is the centre line of the surface work that was and is specified in Schedule 1. The dashed line, north and south of that centre line, is what is called the limit of deviation. Other works are marked there as well, but that is the key one referring to the Bromford line as it comes into Water Orton as originally proposed.
There seems to be a road running along the bottom of the diagram from west to south, or something else. But what you're...
That is, I believe, work, if it's a diversion of Attleboro Lane.
Yeah, but what you're asking us to focus on...
The focus is on the centre line.
The centre line, which
exactly.
then splits halfway across into two.
Exactly.
Yeah, okay,
and it's trying to help your lordship with where the line is referable to the work. So this is one of the three works referred to. And if one goes to the next page, we see the original proposal going westwards and then to the west of the page 312 at the left-hand side, you will see it's headed, there's a sign there, commencement of viaduct.
Just about.
Just about.
No, sorry. We're on 312 now.
We are.
If I can try and assist, it's the darker shaded area on the left-hand part of the diagram. We see the centre line and almost illegible is, and probably is illegible, is some text just above the centre
No, I
line,
see it.
commencement of viaduct.
Correct.
Lord, I have a magnifying glass. That would help.
Thank you.
And then moving,
Sorry, I find these diagrams very difficult to understand. I think I understand the artist's impression or photos, or maybe they're not, maybe they're actual photos, earlier. Can you look at 309? Is the building Bromford Tunnel East Portal building exterior view? Is that something that exists or something which is proposed?
no, that is the proposal, not referable to a deposited plan, but it does illustrate the design of the portal proposed to be erected at Water Orton.
That's your 90 by 30.
I beg your pardon?
That's the 90 by 30 portal, is it?
I believe so.
Well, forgive me, if I've understood this, the application which was before the Secretaries of State included the portal, not the tunnel. It did not include the portal building. This is shown illustratively.
That's correct.
And that would have to be the subject of some other process. I mean, the portal is where the tunnel emerges as a whole.
That's
and
correct.
has a lot of concrete.
But
This is above ground and is a portal building.
exactly. But what's important is that the portal was part of the Schedule 17 application.
Yes.
And
Well, the portal, yes.
yes, and this is an illustration of the portal at that stage.
Oh, is it, so if I look at the railings, is it where we see that space on the right-hand side of the diagram, or the other diagram? There's some railings running from left to right, and there seems to be a space between the two sets of railings. Is that a cutting where the portal is emerging, though we can't see it?
I'm awfully sorry, my lord. I'm not sure which page.
Well, the same one.
Which one's that?
Not easy to see on this bundle.
Mine aren't numbered, but
No, I mean, it's hopeless.
309, if it was numbered, if it had a number on it, I think it would be
309.
309.
It was the one my lord went to.
Yeah. And then there's a colour diagram of the
The
same
next
site
page,
on the next page.
310.
Yes, I have
You can
that.
see the building alongside what seems to be a cutting.
Yes,
So somewhere in there, the portal is emerging
exactly.
below ground level.
Exactly.
May I add further to the confusion? Page 151. Now, the note I have is that one of the things that you were addressing us about was the nature and scale of the changes to the work. And you were talking about the residents and the impact on the new, much bigger portal in a different place, and the compound areas for works. As I understand, that was how we launched into these plans.
It is correct. Correct.
So if I look at page 151, it's a simple so, does that help me? Because I've got my nice little red boxes superimposed, which shows the main compound for the relocated by comparison to the
Construction compound proposed in the ES for the bill.
Yes.
So I looked at that, but the trouble is I couldn't work out which was which.
Well, I just took the view the bigger square was the new one.
Yeah, I wondered
Correct.
that too. But it would
Correct.
have been helpful to have it properly labelled.
Yeah.
But does I mean,
That is the
teasing
correct
apart,
understanding.
does that
Yes.
does that help
Yes.
me?
Yes,
Don't know if it helps the rest of you who are experts, but does it help me?
it does.
Yes,
It does.
thank you.
I'm grateful. And then the photographs illustrate on the next page, at least in March 2024.
So just before we leave 151, I'm so everyone else. The original construction compound is the one top left, is that right?
Correct.
Because the tunnel goes further to the east. So
Exactly.
the two additional, or at least one of them, on the bottom right-hand side of the plan are additional construction compounds.
Correct.
Okay, thank you.
It's really to compare, as I've understood it.
Well, Wouldn't you have needed
page
construction
149.
compound- Wouldn't you have needed construction compounds anyway, in connection with the viaduct? I don't know.
Well, if looking back to 149,
Yeah.
we've got the satellite construction compounds, as I'm instructed, shown there in the orange. And these are shown again by comparison in 151 with the extent of works for the extended tunnel.
As I understand, 149 is part of the ES at the bill stage.
I believe so.
We're looking at the legend at the bottom,
Correct.
part at the bottom. So there seem to be 2 construction compounds.
Correct.
One as the collector road, the A452 curves round to the right,
Yes.
to the north of that, on the right-hand side of the diagram.
Correct.
So again, I'm not quite sure how 151 relates.
From the point of view of inhabitants of Water Orton, is the effect of the revision to the proposals as they were when the bill was going through Parliament, that there will be much more stuff there than there would otherwise have been?
Correct, yes. And that's what Miss Levy has sought to explain. And it's not just a question of what's shown on a plan, but it's, of course, what the effect of those works would be. I've referred to the tunnel and the portal and the compound areas. So far as the effects are concerned, as far as I understand it, a very different length of time involved. I think broadly 2 years. In Water Orton, I'm focusing on now, it is now going to be 5 years. And not just work during the day, but 24 hours work throughout the day and throughout the night. A further point of distinction is the question of materials, excavation due to the tunnel. The screening report indicates that the extended tunnel is going to increase the amount of excavated material to 340,000 cubic metres, originally 130,000. And that's to come out at the Water Orton end. And as Miss Levy describes, landscape and visual effects, which on any basis, and indeed even in HS2's screening report, are said to be significant, including nighttime lighting, which Miss Levy also looks at. Mr.
Is that during the
Gilfedder,
construction phase?
I beg your pardon.
Is that during the construction phase or permanently?
During the construction, that's what's been referred to by Miss Levy over that 5-year period. Just by way as a sort of touchstone, you'll have read that from Mr. Gilfedder's witness statement, he refers to a change in scheme at the Euston Station end. Have a look at that, and bear in mind that Mr. Gilfedder describes that change as a very significant one, And with respect, I think that phrase is even more apt, and should be from his opinion, to the change that's happening with the Bromford Tunnel Extension, a very significant one. Now, so far as the nature and scale of the proposed works is concerned, a concern that the authority has on behalf of people and residents in the borough, local people were denied the opportunity to petition against the bill on the basis of the changes and the impacts. I've indicated already, with reference to Ms Levy's opinion, that the scale of change could not reasonably have been anticipated for residents of Water Orton. But more than that, the changes that are now sought were expressly rejected. And the reference to that is in the supplementary bundle at page 59.
Rejected by who?
HS2.
Page 59 of the supplementary bundle.
Of the supplementary bundle.
Paragraph.
2.6.18.
Thank you.
You're looking at the index. This seems to be the first page of an extract from the environmental statement.
Correct. And
For the bill?
correct. And it was a document called Community Forum Area Report. So it's directed at informing people who might be affected and want to understand the scheme.
But it formed part of the environmental statement.
As I've understood it, correct.
Thank you.
The potential for a longer tunnel, moving the Eastern Tunnel Portal to... I'll let the court read.
CFA report.
Community Forum Area. So each part of the environmental statement was divided into particular areas for help. So it's not just a case of standing back and asking the question, could local people reasonably have expected such a change? It's actually that they were being told that that particular change was excluded, was not an option. That's the second matter by way of introduction I wanted to deal with, in other words, the nature and scale of the works.
Just before we leave that, one short question on the deposited drawings. I mean, basically, in a nutshell, what they show by way of a centre line is the location of a viaduct or a tunnel or an embankment, and also the limits of deviation either side, and sometimes I think they also show levels.
Correct, they do, yes.
But that's really the extent of the detail that's gone into. Is that broadly right?
There are also the sections which are in the
sections
tab, yeah.
which again show what the location of the works,
Yes,
and limits of deviation.
yes, and where they are in terms of whether
So
they're
an analogy,
surface
I
level.
think, is drawn by the other side between drawings of that nature and an outline planning permission.
There is, but I think it only goes so far, bearing in mind the details shown in the schedule by reference to the deposited plans. They are actually quite specific.
Well, it says what the nature of the engineering is. Yes,
Yeah, exactly so.
I built that into my question.
Yeah.
Right, thank you.
Yeah.
Just like, for example, you might have an outline planning permission for an industrial estate, and it describes the nature of the development in broad terms, using words.
Yes, but if it was to do more than that,
Yeah.
it would be even more specific.
Yes.
And that's what happens in Schedule 1 by reference to the deposited plans.
Yes.
So, reference to an outline planning permission, we shouldn't be thinking of some sort of bare outline. This is a definition of a scheme, and it is very specific, as I shall indicate. So the third matter I wanted just to touch upon is just to give a very brief overview of the scheme of the Act and the particularly relevant sections. And I'm ready to answer any questions, but at this stage, I'm hoping really just to give the overview, and then I'm going to dig deeper. Okay.
No pun intended.
So, the first section, section 1, coupled with schedule 1, that's a power to construct and maintain works. There are 2 categories of work. I'm going to come into in detail to these. I just want to highlight really the issues that are arising in hopefully very just simple, broad terms. A proper understanding, we say, of this section and this schedule is crucial to understanding the scope of section 2. And the question really for the court in relation to section 1 and schedule 1 in broad terms is this a fixed list? Or does section 2 allow amendments to it, or in some other way, changes to the works as specified? Section 2, this is the power to do other things. And we say broadly, these works are not only other than, in other words, different from the works in Schedule 1, but they need to be ancillary in a way that I shall look at in more detail to those works. The learned judge decided that section 2(1) I provides power to authorise the new tunnel, the extended tunnel, and the portal, even in circumstances where this would conflict with Schedule 1. And so the court needs to consider if this subsection is so wide as to permit such a change from the principal works. And, I emphasise, importantly, a significant change to the railway formation itself. In other words, the railway on viaduct, as opposed to, I'll make this point more clear when I come to the legislation in more detail, as opposed to other works consequential upon or incidental to. So the one key element here is the railway and its formation, whether it's on surface, on viaduct, or in a tunnel. Section 20 provides that planning permission is deemed for scheduled works and also for works covered by section 2, but only if the 3 criteria set out there are met. It's akin to a planning regime, but it's not the same. It's not the same, one, because I've already given an indication of the specificity in Schedule 1, and also the powers in Schedule 17 related to conditions are more restricted. And again, I'll look at that in a moment. The issue is the interpretation of the 3rd criterion. And the question, is the change scheme covered by the environmental statement before Parliament?
But it's also subparagraph A as well. when we look at paragraph 13 of the decision.
Yes, it requires an interpretation of all three, but reliance is placed on the third. That term is defined in section 68 as meaning if it is development in relation to which information is contained in the environmental statement before Parliament. And my learned friend Ms. Ollie will be taking the court to that provision. But in short, the relevant question, as I urged upon Mr. Justice Dove, is where is the information relating to this change development in the environmental statement?
Well, as I understand what subsection 4 is doing, is it's talking about information from an environmental statement as required by those regulations.
That's correct, but it's
which we need to look at in due course.
Yeah. And Schedule 17, this is an approval system for conditions to control details relating to various matters. Plans and specifications. It's looking at the details here. And it's relevant here to look at the statutory guidance in the authorities bundle.
Tab 5.
Correct. Which was the document we handed in this morning. And if I could ask the court to make a note of the following three paragraphs in particular. First of all, paragraph 11. And then paragraph 20. And pausing at paragraph 20, although this is advice given to planning authorities, it chimes well with our submission that Schedule 17 does not provide the opportunity to revisit matters settled through the parliamentary process. And Section 1 and Schedule 1 were settled through the parliamentary process.
Well, that's not purporting to give guidance on the scope of Section 2, then.
No, it's looking at that next stage of Schedule 17, which, as I've said, is to look at the details of works that have been authorised either under Section 1 or Section 2. So, whilst your Lordship is absolutely right to say it's not something governing Section 2, it is nonetheless an indication of further down the line there shouldn't be at any stage of the process some attempt to revisit things that were settled at the parliamentary stage. And 36.
But how detailed is that? I mean, that, in a sense, are you saying that every detail of what was approved in the process which led to the enactment of the Hybrid Act, every detail must be a matter settled through the parliamentary process? So if you move anything by so much as an inch, you're revisiting it?
No, not so much of an inch. What I'm drawing attention to is what's approved under Schedule 1 relates to the nature of development, the type of development, and it's restricted to the limits of deviation. So it might be for works to divert a watercourse, for example. But where there's a building proposed, then that will go through the process and conditions are imposed via Section 20, Schedule 17 is an opportunity to look at the details, but it's not an opportunity to change the nature and type of the development authorised by Parliament. I think that's the mischief here.
This is basically, this paragraph 26 of Schedule 17 says, guidance to the authorities on their functions. So it's telling them what they can and cannot do when they receive a Schedule 17 application.
Correct.
But secondly, a Schedule 17 application applies to, as you rightly say, Section 1 scheduled works and also unscheduled works.
Yes.
But this is not telling us anything about what unscheduled works can or cannot include.
What it is doing is saying that when it comes to looking at the details for unscheduled works, authorities...
What they cannot do.
Exactly.
Yes, but that's not telling us anything about what unscheduled works can embrace.
I've acknowledged that.
Okay.
I've acknowledged that, but what I said is it chimes very well for the underlying message that the process does not, and I'm explaining this in detail in a minute, admit for the sort of changes that are being proposed here to the Schedule 1 works.
Obviously, a change in the route would be revisiting something settled in the Parliament.
If it went out with the limits of deviation.
Yes.
Yeah.
Yes.
Yeah. So there is that flexibility. Nobody's denying that, but it's quite a restricted flexibility. Having undergone a very detailed process at the parliamentary stage.
There was a third paragraph.
You had a third paragraph to take us to. We've got 11 and 20.
Sorry.
No, I'm very grateful. Paragraph 36, I think it was.
Thank you.
I think it's very much the same message that I take. So, I think that's all I wanted to say by way of an overview, and I hope helpfully indicated in broad terms the issues arising. But I do want to now look in a bit more detail at these provisions, and for my part I'm focusing on sections 1, Schedule 1 and section 2, and Ms. Holly will follow on in relation to section 20. So I think this is the right time to have the statute near to hand. Looking first at section 1, these are my submissions about section 1. The first thing, as I've already said, forgive the repetition, but it is really important, the scope of section 2 cannot be determined without a proper understanding of section 1 and schedule 1. The second point to highlight is that there are two elements of works referred to in the section. The power to construct and maintain two categories of work as specified. The first is the construction of the railway itself, and the second works consequent upon or incidental to those works. Now, it's really important to keep those two categories in mind, bearing in mind that the proposed change centres on a change to the construction of the railway itself. The first category, therefore, is central. It's the central element to the authorisation under the Act. It's the primary work relating to the formation of the railway itself. The second category is what Parliament at that time said, well, given that work, that construction, be it tunnel, surface or viaduct, there are certain things that are consequential or incidental to that work as identified, and that's set out in the schedule as well. The explanatory notes calls the two categories together the principal works. I'm drawing attention to the fact that there are two categories within the principal works, the first being a key central element, which is the railway, which in effect governs everything else. The next point is both categories of work are said to be specified. That's, in my submission, an important word being used by Parliament here. It's specified in Schedule 1. It doesn't simply say there's an illustration or the parameters are set out or there's some sort of broad description in Schedule 1. The works are said to be specified. So we know that the power, the authorisation, can only relate to works as they are specified in the schedule. We'll come to the schedule. We know, therefore, according to this section, that the schedule is not to be read as some sort of generalised or flexible description that can be departed from. Schedule 1 is literally specific. The Act has, therefore, at this stage relating to these works, set down and fixed what the principal works are, both for the construction of the railway and what is consequential or incidental to that work. These works have been settled by Parliament. The next point, which almost goes without saying, is that there's no power in Section 1 to amend the specified works. It's clearly not said, and there's nothing that could be taken to suggest it. Indeed, the use of the word specification is to the opposite effect. And in particular, there's no reference to Section 2 as some sort of enabling device to amend the specified works or to do something different to that effect. The power is strictly limited to the works as specified. And there's good reason for that. These works were scrutinised and approved in Parliament during the lengthy passage of the bill and were available to stakeholders, local authorities and the public. And have in mind in this context, Ms. Ollie will talk more about the environmental impact regime here, but it's not all about EIA. Okay, EIA, obviously a critical part of the process, but it's not just about consideration of environmental impacts. When these matters went through Parliament, there were matters other than environmental impacts which were relevant. Cost, economic impacts, social impacts, those impacts that might not squarely fall within an environmental statement or are not required to be set out in an environmental statement. They all go towards informing the decision that Parliament ultimately made, which is whether to authorise the works. So, Schedule 1.
But when, as a matter of interest, when we come to Section 20, subsection 2, and the constraints on the scope of the deemed planning permission, subsection 2, are expressed in environmental terms, not by reference to economic or social impacts.
Correct. Correct. I think that only makes my point stronger,
Right.
is that that safeguard only relates to environmental impact. Well, the horse is already bolted in one sense. If through some other means.
But what it's not doing is to say you're outside the scope of the deemed planning permission because the social or economic effects are different to that which was previously considered.
It's the point I've referred to through Schedule 17. Those conditions provide only a limited ability.
Well, that's a different point again. I'm asking you about the scope of the deemed planning permission.
Yeah, but it's a point, whilst different, that has exactly the same mischief, that the importance here is what is authorised by Parliament in Schedule 1 and Section 1.
Thank you.
Schedule 1, page 1 and paragraph 1 is the first port of call, and we see here that the scheduled works must be constructed in the lines or situations shown, in accordance with the levels on the deposited sections, and in the case of any station, depot or shaft, for which an upper limit is shown on the deposited section with the limit so shown. Just pausing then on paragraph 1, we see that the use of the words must makes clear that these provisions are mandatory.
Well, I was going to ask you about it. Does must mean can only be? This is grafted onto a power to construct the works.
This is, if
this
those
is not an obligation to construct.
There's a distinction there.
Yeah.
Yes, it is mandatory. If those works are carried out, they must be done in
Therefore, it means can only be.
Yes.
Yeah. The limit of your authorisation pursuant to Section 1 and Schedule 1 is in accordance with what we see here. Okay, thank you.
And the works are defined in the schedule. We note in particular from the text in the schedule, and it's worth having that to hand. We handed in copies of the text of the schedule earlier this morning. If you'd be kind enough to turn to page 103 in the text. And just have that to hand, but let me speak more broadly about the context of the schedule. A quick glance will tell you that there are two categories of work set out here, two main categories, exactly reflecting Section 1 and the two categories that I sought to emphasise quite distinct. So the first is the railway works. So, for example, on page 103, towards the bottom of the page, under the heading County of Warwickshire, etc., work 3157, a railway, partly on viaduct. The other category of works are those that Parliament decided were consequent upon or incidental.
Like 159, for example.
Exactly. Exactly so.
Can I ask a question then if we turn to the next page, 104, because we're dealing with work number 3200.
Yeah.
And it's into work 200 that the tunnel is proposed to be extended, as I understand it. You clarified this earlier this morning. All that 3200 describes is a railway, 2.06 kilometres in length. It doesn't say whether it's going to be an embankment or whether it's going to be on a viaduct or in a tunnel. Very non-specific to that extent. Does that mean, if I've read it correctly, does that mean that the undertaker can build a tunnel or a viaduct or something on at grade?
No, I think at that point, because we're now in the city of Birmingham,
Yeah.
it is at surface. I think it's correct to say. But when we go further
No,
west...
I'm asking you a question about the form of the railway.
So I'm dealing with that question.
Yes.
So it's on the surface, so it's not...
Where does it say it's on the surface?
Because it doesn't say it's on viaduct or in tunnel, and the deposited plans will show it's at surface level. If you
Yes,
look...
but the deposited plans are subject to limits of deviation.
Of course.
So far as vertical deviation is concerned, is up to, I think it's 3 metres.
That's correct.
And otherwise, going downwards, unlimited in extent.
Subject to a qualification that I'll come to.
Okay.
Okay. If your lordship looks further down the page to work number 3203,
Yeah.
a railway commencing by a junction with work at 3200. So there it is in tunnel.
Oh yes, there it is.
Okay. So there are 3 types of construction for the railway, that key central element of section 1. It could be in tunnel, it could be on viaduct, but where it isn't, it's at surface level, subject, as your lordship rightly points out, to the limits of deviation.
Surface level is variable too, because at some points it
As
could
shown
be-
on the deposited plans.
At some points it could be in cutting.
Correct.
And the deposited plans, do they show cuttings?
I
Do
don't.
they show that level of engineering detail?
I don't think they showed that. No. So each work is described with some precision.
And equally, sorry to interrupt again,
Of course.
I'm trying to make sure I understand this. If a railway may be constructed on an embankment, does the schedule specify that? Or does it leave it to subsequent detailed engineering design?
I think that it's not in the schedule, and I don't believe it's shown on the deposited drawings. So insofar as the railway is on surface level and requires something, in other words, something ancillary to it, do you follow me?
I think I do, yes.
No, I didn't mean that in any, of course. But sometimes I don't make myself clear. Then, if it's properly ancillary to the construction,
then
that's the point. So each work is described with some precision, and in particular the nature and type of the work and its location. The primary works of the railway is defined. Where a tunnel or viaduct is part of any railway work for the construction of the railway, this is part of the defined work. So the formation of the railway is fixed in this way. Tunnels and viaducts are seen to be treated as part of the railway construction works authorised under section 1, that first part, that key element, that first category, the railway itself. And the specified consequential works will obviously flow from the type of that development authorised. We've looked at the deposited plans to which the text refers, so I only want to highlight 2 points at this stage. Each railway work has to be constructed in the lines or situations shown on the deposited plans. That's paragraph 1. That's mandatory. Second point is, whilst the deposited plans and sections are not part of the statute itself, they are incorporated by reference. The line of the railway is shown, the level of the railway is shown, the lines and levels have no doubt been fixed with care, and even where the line goes into tunnel, the depth is shown. whether it be 20 or 30 metres or whatever underground. So moving from the deposit plans to the limits of deviation, the mandatory instructions within the schedule are subject only to the limits of deviation. And there's no other flexibility provided for the works in terms of their location or situation. The flexibility is limited to that which is shown by the limits of deviation, which you recall when we looked at the plans, does allow some flexibility, for example, along the centre line, so it can move. But importantly, the limits of deviation do not allow changes to the works themselves, and nor could they be relied upon in our submission to change the nature of the defined works. Your Lordship referred to the lateral and vertical limits of deviation, and some reliance has been placed on little b, vertical downwards to any extent from the level shown for that work on the deposited sections. So, yes, it provides flexibility to move, in this case, the line of the railway downwards. But what is pretty important here, very important, is for that work. And for that work means, in the case of the extended tunnel railway, the railway in tunnel, or partly on viaduct. It doesn't provide any means by which the nature of the works can be changed. And the last point here is that there is, of course, not even a suggestion here. Is that mine? I do apologise. I have a hearing problem, and it doesn't matter which device I use. It provides one problem or another. So I'm going to switch this off, and hopefully, it may mean I can't hear a thing. But
well, tell us if we're not speaking up adequately.
Well, I'm grateful. If you could bear it in mind, I'd be
of course.
Immensely grateful. Yes, there's not even a suggestion here that there's power to alter the scheduled work somewhere else. It could have easily said, subject to Section 2. It doesn't. And to be fair, I think that's a relevant question to ask. Well, if it meant that, you could have said so. If I could ask the Court to pick up the supplementary bundle and look to page 125. The Court will have seen that there are a number of information papers explaining the purposes of various things, for example, on the parliamentary plans in this case, but other matters too, as we can see. On page 125, in the square box, the purpose of the document is set out. It would be of particular interest, it said in the second paragraph, to those potentially affected by the government's proposals.
Sorry to interrupt. What is an information paper? What's its status?
It's not part of the Act. It is
No.
an explanatory note, I understand, issued at the time in order to explain to the public and stakeholders the purpose
It's not part of the environmental statement.
No.
But was it during the build process something given to the committee?
Yes, that's my understanding.
Thank you. Sorry.
No, not at all. Not just given to the committee, but...
Well, published generally.
Yes, exactly. And the third paragraph sets that out in just a little bit more helpful detail.
So that was paragraph...
The third paragraph in the box, my lord, on page 125.
Okay, thank you, yes.
And if you turn, please, to look first at paragraph 3.1 to 3.3, and please read those paragraphs, and paragraph 3.5.
Well, it's just really summarising what the statute is telling us. Is it adding anything?
I think it's broadly supportive for the message that I'm trying to convey, that the statute, far from being, it's section 1, schedule 1, far from being some...
Yeah, but I don't think the other side is trying to justify the legality of the tunnel extension under section 1 and schedule 1.
No, they're not, but as I've indicated or sought to explain, one can't understand section 2 without a proper understanding of the rigour of section 1. 3.5, the design shown on the bill drawings is a preliminary design. The powers within the bill must therefore be sufficiently flexible to allow for adjustments once detailed design has been carried out. This is achieved by including powers to deviate from the position of the work shown on the parliamentary plans by a small amount. This deviation is restricted by the LOD marked on the plans. So the point here is, yes, of course, it's supportive and says, in a way, no more than what I've said, but it does support what I've also said, which is that what is here is a fixed design at the time Parliament gave its endorsement, but the flexibility is contained within the limits of deviation. There's no suggestion here in the guidance that, well, don't worry, you can change it all when you get to section 2. A further reference is on page 131, and this is a different information paper relating to control of environmental impacts. And again, could I ask the court to look to paragraphs 3.1 to 3.4. In 3.4, in particular in the preamble, note that in the case of any development authorised by the bill which consists of the carrying out of a work other than a scheduled work, that is to say the work 1 is not described in Schedule 1 to the bill, permission is only granted, and then there's a reference there to Section 20. So the point to take there is supportive of my submission, that when we get to Section 2, we're dealing with something different. We're dealing with works other than in Schedule 1. By definition, unscheduled works.
Just in passing, the 3 bullet points there are a sort of summary of subsection 2. They're not expressed in the same language. They're linked by the words or rather
Yes.
than and.
Which is a very,
And then that's partly because of the way the first and third bullet points are explained. I think it's the use of the word not. It's
I agree.
the reverse of what we eventually see in the statute.
So the cumulative.
Yeah.
Now, the learned judge, in dealing with Schedule 1, it's worth getting out the judgment and look in the full bundle. I think it's page
31.
Thank you. And in the judgment, I'm looking for paragraph 30, which is on page 43, I hope.
Yes.
Now, Mr. Justice Dove, as it then was, is referring to the
Can I
text.
issue
I
an
beg your
edict prohibiting you from saying, as he then was, anymore? You said it once. We know who he is.
Gosh, I'm so grateful. That's going to ease my burden. Makes reference there. He says Schedule 1 is containing more properly parameters rather than a specification of works. But with respect, this, in my submission, is to not do justice to the statutory language and is to loosen its intent. The statute does not use the word parameters, even when it talks about the limits of deviation. Those terms and the plans are strictly specified. The word parameters may be that the learned judge was, in one sense, looking ahead to something when he was going to get to the question of environmental impact assessment. But here, in relation to the statute, the word doesn't properly reflect the strict or precise nature of the schedule. And in particular, the learned judge fails to acknowledge the fact that the schedule fixes the primary works, the principal works, subject only to the LOD, carefully defined scheme, especially the primary railway works, which, as I've indicated, there's no provision to change the type and nature of those works. And in my submission, that paragraph and his preference for the word parameters is wrong.
Well, if he'd said instead, provides a specification and parameters, I mean, parameters is just another word for limits of deviation.
Well,
Would that be objectionable?
if he'd not used the word parameters and had referred to the flexibility only provided for in the limits of deviation, containing no provision to alter the nature or type of development, that would properly reflect my submissions. But that's not what the learned judge does.
Isn't that what he says in the concluding lines of the paragraph?
He refers to the limits
parameters in the sense they contain the limits of deviation.
He says that, yeah. But he doesn't, it's my submission, in my view, by adopting the use of the word parameters, not specifically related to the limits of deviation. First reference provides a specification, but his preference is to say, no, I'd rather use the word parameters.
But then in 31 he says the nature of the scheduled works, and in particular those which have been specified, is the background to the central issues. And then he makes the point, no one's saying here on the other side of the argument that the tunnel extension is a scheduled work.
Yeah.
And it really all then boils down to section 2.
Well, yes, it does, of course, end up with a need for discuss the scope of section 2, but section 2 can only be properly understood if you want to proper understand.
Section 1.
Exactly.
Yeah,
and if one takes the view, and it may be totally unfair to focus on the use of the word parameters, but with great respect to the learned judge, it's not a word that springs from section 1. It doesn't do justice to the strict wording of that section and the specificity and definition of the works carried out, set out in the schedule. That's the point.
You're saying it overlooks the importance of the specification of the form of the railway.
Yeah. Paragraph 35 of the judgment, yes. It's another reference to Schedule 1, where the learned judge says the claimant notes that the tunnels are on occasion specifically identified within the schedule. Whilst it's true that tunnels are occasionally specifically mentioned in the schedule, it doesn't, in my view, provide any justification for constraining the obvious broad language of section 2(1)(i), which we'll come to. But at this point, and again, I'm sure you're going to come back to me and say, well, you can look more broadly at this paragraph and everything. But to be fair, I think this paragraph and the use of the word occasional, again, doesn't do justice, sufficient justice, to the specification and rigour of Schedule 1. In fact, tunnels are referred to over 35 times.
Well, it's 20% of the route. I think we got that point.
It's another one, but yeah, but it's not an occasional reference. I mean, as a matter of fact, I don't think that is an appropriate description. Viaducts are used over 40 times. And what one takes from that is not just some sort of isolated observation of no worth. The point here is that when the Act does refer to tunnels and viaducts, it's in the schedule. It's not, as we shall see in section 2. And when it is in the schedule, it refers to the central element of the railway construction, which governs everything. And so the learned judge here fails to acknowledge, in my submission, that tunnels and viaducts are deliberately specified in the schedule as integral to the formation of the railway itself. As we shall see, they're not dealt with in section 2, which deals with other things than the scheduled works. It's no answer to say, as the learned judge does in paragraph 36, that if Parliament had intended section 2 not to include reference to tunnels or viaducts, they would have said so. That's not a safe conclusion in my submission, bearing in mind the way tunnels and viaducts are dealt with in the Act and in the schedule. The proper conclusion is that they are not referred to in section 2, because that section is dealing with matters other than Schedule 1 matters. It's perhaps an appropriate moment just to pause. What the court will have appreciated when reading the judgment is that there are a number of references to the purpose of the Act. And of course, that's part of the unified process that governs interpretation of statute. But in our submission, what's happening in the judgment is that the purpose is being expressed in overly wide terms without a proper acknowledgement of the deliberately specific authorisation given to the works for which power has been given. And we say that any purpose so defined must recognise and acknowledge there's a clear process being set out here and a defined scheme of principal works, allowing for some flexibility, but the flexibility is clearly set out. In any event, we say that the statutory purpose, however it's described, must not subjugate the clear language of the statute. And we say it is sufficiently clear when read in context with the purpose more clearly defined. So just to try and summarise my submissions at this stage on Section 1 and Schedule 1. 7 points. The power in Section 1 to construct the railway is restricted by reference to Schedule 1. Schedule 1 defines the nature and type of the works as well as their location. The only permitted flexibility is by reference to the limits of deviation. There is no flexibility, however, as to the nature and type of the works, which are fixed. I should have enumerated these, but I'm turning to my fifth. In particular, the primary works for the railway itself is defined carefully and is sometimes in tunnel or on viaduct. Sixthly, this is how Parliament considered the bill and how the environmental statement was addressed. And seventhly, Schedule 1 therefore operates as a fundamental part of the Act's control over environmental impacts. In other words, in defining the nature of the principal works and their location.
And have I got this right? An embankment or a cutting is all right, but a viaduct or a tunnel must be specified.
The embankment, if it can properly be characterised as ancillary to the construction of the railway, is something that might be covered under Section 2. Section 1 governs the construction of the railway, and where it's in viaduct or tunnel, it is so stipulated.
I'm having slight difficulty with the notion of an embankment as ancillary. It's integral, it is the railway. Without it, the railway would be in air.
Yes,
It would need a viaduct.
well, I think it's a natural inference that if the railway is not on a viaduct, not in a tunnel, and shown to be, as it were, at surface, then that's implicitly telling you what the construction is, that it's not on viaduct and it's not on tunnel, but it may be to accommodate that railway as it's constructed would require an embankment. Now, a further point just to make here is the Secretaries of State and the interested parties say that the Act doesn't require that the scheduled works are constructed. But with respect, that misses the point here. First, Section 1 does require that the railway is constructed as it is defined in Schedule 1. There's no power under Schedule 1 to construct a railway other than is defined So it's not part of the case against me that, well, we're not going to build the railway. So it follows that if you're going to accord with Section 1, Schedule 1, that railway has to be constructed in accordance with Schedule 1. Secondly, insofar as any change to the schedule
That means all of it, presumably.
correct.
Thank you.
Insofar as any change to the schedule works in this respect is required, a separate power is needed. And have in mind that this was the original position of HS2.
Just take us that. So you've taken us to the part where they say it wasn't proposed to include the longer tunnel.
Yes, to exclude the longer tunnel.
Yes.
And it's another document I have in mind, my lady, which is the supplementary bundle, tab 19, at pages 171 to 173. Now, this is a document called a screening report, an environmental impact assessment screening report. It's dated February 2021, and it relates to, it's in the context of the Transport and Works Act. And if you look to page 171, can I ask that you read paragraph 1.1.2, please?
So this is the screening report for the TWOA
Yes,
order application
correct,
relating to the deletion of 30 metres of viaduct.
correct.
And it was paragraph,
1.1.2, my lord.
sorry, thank you.
So the points to take there are that HS2's position, at least at that stage, was that there was an accepted need for a separate permission to authorise the extension to the tunnel.
Where that section would otherwise be viaduct,
Yes,
because the tunnel would not be a viaduct.
correct.
On the other hand, they didn't see the TWAO as necessary in order to authorise a tunnel.
That was a later position.
No, but even at this stage,
Correct. Well, absolutely. So a number of points to take.
two
from this.
aren't necessarily consistent.
Well, as I've said, HS2's position was equivocal, and one can see it articulated in various different ways. But leaving that to one side, this is the original position, an accepted need for a separate permission. Secondly, no reliance on limits of deviation. Your Lordship's point that, well, downwards, and I've said, well, only for the work defined. No reliance on
It's
that.
got to be consistent with the nature of the work specified.
Exactly. No reliance on Section 4 of the Railway Clauses Act, or indeed any other earlier legislation, which is now prayed in aid, of course. No reliance on Section 2 to achieve authorisation. Indeed, it's accepted in terms that the extended scheme is a change. And if one looks...
That's why I asked my earlier question. This I don't find terribly helpful because it's only dealing with half the story. It's removing the word viaduct, or overcoming the use of the word viaduct in the statute, by promoting an order which deletes that. But on the other hand, it doesn't, secondly, say tunnel.
No, Absolutely.
So, if that's the nature of the proposal, which I find a bit difficult to grasp, you wouldn't expect it to talk about Section 2 to authorise positively a tunnel, because it's not dealing with that. It only takes one so far.
Well,
for my part, it's not helping when it comes to interpreting the statute.
Well, I think of itself it's not, but what I'm drawing attention to is not just for the forensic purpose of HS2 having an equivocal position, but actually some support for my position, which is that a separate permission might be needed where there is a change of such fundamental nature to a Schedule 1 works. And that was, in effect, what HS2 are setting out as their position here. In terms, it wouldn't, there can't be an authorisation for the proposed development, including a tunnel, because it would conflict with the Schedule works in Schedule 1. That's our case.
But then HS2 withdrew the request for a screening decision.
I'm sorry, Mark.
Sorry, they then withdrew the request for a screening decision.
I think that's initially correct, and then it was then determined in the later correspondence with the Department of Transport, eventually determining that an environmental assessment was required and that HS2 had in effect not applied the correct test in the context of the TWA, which Ms. Ollie will deal with. In other words, the test was not, are there different effects, but are there likely significant effects under the directive?
Yes.
Okay.
That's the letter at page 226 to 7, which was sent about a month later on the 31st of March. You've taken us to document in February 2021.
Correct.
And this is the response at that stage from the
Correct.
department. And you've referred us, I think, to a passage at the top of page 227.
So, my Lord, that's all I wanted to say, important though it has been, in order to understand and properly interpret Section 2. So, with Section 2, open in front of us, can I make the following 4 main submissions. The first is a very short one, that Section 2 in our submission relates to works that are not Section 1, Schedule 1 works. It relates to other works. And actually, it sounds like quite a sort of almost self-evident point. But actually, if you keep it in mind, it makes the interpretation which we urge upon the court sound like common sense and makes better sense with the statute. It's dealing with other works, not Schedule 1 works. The second submission is this, that Section 2, and this is self-evident, I hope, on its face is not a power to authorise alterations to those works or to amend the schedule. There are no words to this effect. Now, the learned judge responded to that submission at paragraph 33 of the judgment on page 44. And then at paragraph 34, the first point raised by the claimant is that section 2.1 is not a section which creates a power to amend Schedule 1. That's correct, but it's not to the point, he says. The purpose of section 2, as set out, is to authorise other works. Absolutely right, and actually very important, which are within its scope and related to the scheduled works or the phase 1 purposes in the manner specified in the section itself. And then he says there's a sense in which section 1 and 2 are complementary to each other and also to the purposes of the Act. Given its scale and nature, it's clear Parliament regarded it as unrealistic for every last detail of what would be required for the project to be successfully implemented and maintained at the outset, as specified. Is therefore within the structure of the Act identified parameters and constrained flexibility to ensure the project is delivered effectively. In response to the learned judge's comments here, when the learned judge says that my submission is not to the point, we, with respect, disagree. It is absolutely to the point, because the Secretary of State's argument is, in effect, aimed at doing just that. It is, as I've sought to emphasise, Schedule 1 that provides the power for the construction of the railway. On the learned judge's approach, Section 2 would serve to override that power. Authorisation would be given to a very different railway work, which would be in conflict with Schedule 1. The whole point of Section 2 is to deal with things other than Schedule 1 matters. And his reference to there being some sense of complementarity, with respect, we say is misdirected. Whilst there is a relationship, there's no two-way direction or connection such that Section 2 can serve to, in effect, change the works in Schedule 1, which sets down specified nature of works subject only to their location. So that's my second submission. The third broad submission is this, that in our submission, Section 2 is an ancillary or incidental power. It's to do things to accommodate the scheduled works or the operation of the railway. Indeed, reference is made by others to the 1845 Act, Section 16. Interesting, in the sense that it deals with the construction of the railway, and then the phrase is accommodation works. And that's exactly what we say.
Well, accommodation works typically refers to works done on third-party land so as to ameliorate the adverse effects of the railway on neighbours.
In part, but in the context here, it's dealing with, we say, works which accommodate, receive the Scheduled 1 works.
Okay.
Ancillary is how the explanatory memorandum describes it. That's in the authorities bundle.
Tab 6.
Tab 6. And
page 15. Oh no, that's section
it's
20.
page 11, I think.
Sorry, yes, I'm looking at section 20.
You see, section 1 is referred to paragraph 18, the use of the phrase the principal works, and the details set out in Schedule 1, to which we've referred. And then paragraph 19 allows the nominated undertaker to carry out ancillary works. The court will have also seen Miss Levy's reference to the Crossrail Act and how that term is used, how the same provisions are described in the context of that Act. The learned judge suggested that this was an attempt to elevate the explanatory memorandum over the statute. That's not what is being done here. Case law is quite clear that documents such as the explanatory memorandum can help to shed light on the meaning of the statute. My learned friends refer to the case of the Crown against SSHD in the authorities bundle at tab 17. And the reference they give the court is at paragraph 30 of the judgment. The extract they provide, I don't think is full enough to properly reflect what is said in the court.
So paragraph
30.
30.
So, ancillary, we say, is an acceptable and appropriate synonym or a shorthand for what section 2 is about.
Can I ask you about that, please? If we go back to section 2, subsection 1, I understand your submission that this is just simply dealing with ancillary works, ancillary to the section 1, schedule 1 works.
Yeah.
But if we go to the opening words of subsection 1, the nominated undertaker may, for the purposes of or in connection with the scheduled works, those words in themselves would be sufficient to authorise ancillary development.
That's how we interpret that phrase to mean ancillary. One, not the scheduled works, albeit connected to them, and two, helping to accommodate those works.
So if that's all that Parliament intended to do, why did it add the words or otherwise for phase 1 purposes and then go on to have an elaborate definition of what is a phase 1 purpose? And last question, those additional words are not dealt with in the explanatory notes.
No, not in terms, although the explanatory memorandum certainly uses that word more holistically to describe the,
yes,
which I think is helpful and does help to govern the phrase otherwise for phase 1 purposes, which the Lordship has rightly highlighted because that's where the predominant reliance is placed by my learned friends. So looking at that paragraph, at that phrase, we should next go to find the statutory provisions that help understand that phrase. Section 68, which is the interpretation section.
Sorry, just before we leave section 2 again, you described the case against you as being under Section 2, we can do anything. That we can only do anything within the Act limits, which, as I understand it, means that the territory which is marked out by the deviation limits.
Yes.
So you can't use the authority of the Act to start putting up buildings half a mile away, and you certainly can't change the route beyond the deviation limits. So it's not as broad as all that, is it?
It's not broad at all. No, it's not only governed and restricted by the limits of deviation, which by no means are generous or extravagant. They've been carefully defined to accommodate likely works.
Yeah.
And importantly, there's no provision, we say, to change the nature and type of the works, and in particular the construction of the railway, that first category in Section 1, from which everything flows.
Well, it does seem odd to me, looking at Section 2(1) of this Act for the first time ever, that within the Act limits, the undertaker is given power to do all the things of A to I, but you say not create a tunnel or a viaduct unless that was specified in Schedule 1.
Correct. And the answer is in part because of all the submissions I've made, that tunnels and viaducts and the construction of the railway, the nature and type of construction is addressed in Schedule 1. And it's in part because Section 2 in that context, properly understood, is referring to works to accommodate the scheduled works. In other words, to receive them in the environment, to facilitate them, not to do something different. These are works other than the scheduled works. That's the first submission that I make. Keeping that in mind is an answer to a lot of the submissions made, dealing with other works.
But little I carry out works of whatever description as may be necessary or expedient. That's pretty broad.
It would
And
appear
you
so.
say that can't cover
Yes,
deciding that it's expedient to have a tunnel instead of a viaduct,
correct.
still within the area of deviation.
Correct. We do say that that doesn't permit the change that's sought here. And I'm going to come to little I in a little bit more detail. I quite understand you jumping to it. Well, that's the provision that reliance is made upon, so it's very important we look at it. But here, in answer to Lord Justice's specific question about otherwise for Phase 1 purposes, it is necessary, and I'm hoping to help on understanding that work, which we understand is something different from for the purposes or in connection with the scheduled works.
Well, it's going beyond ancillary.
No, not necessarily. It's only saying that something...
Unless it's OTOs.
It's saying otherwise for Phase 1 purposes. So one has to understand it, look at what the purpose is of Phase 1, what it's all about.
In any event, you accept that if Parliament had not included the words or otherwise for Phase 1 purposes, the preceding words would be sufficient to cover ancillary development, ancillary to Section 1 and Schedule 1.
Ancillary, yes.
Yeah.
Yes, that's really, we say the whole section is about works that are ancillary in that sense. So Section 68, the interpretation section, on page 2, second page of the copy, in my bund at least, 2/3 of the way down, Phase 1 purposes is to be construed in accordance with Section 67. Okay? There's not a lot of help given there.
Well,
But
we've got Section 67.
we have Section 67 just before 68, and we need to look at that. and references to this Act to anything being done or required for Phase 1 purposes are to the thing being done or required, and then there are these things set out. So we've got to remember when we're looking at this that we're looking to understand the phrase within Section 2. In other words, in the context that I described and its relationship to Section 1. There are, I think there's at least one other reference to Phase 1 purposes, which relates to a Scottish Act, which might give rise to the need for some change. But there's three things set out from A to C here. Little a, for the purposes of or in connection with the works authorised by the Act. That really doesn't take us any further forward at all. It seems to be a reiteration of the first part of Section 2 preamble.
Well, what it's saying, perhaps, is that works for Phase 1 purposes could be ancillary to works otherwise authorised by Section 1 or by Section 2. For example, subparagraphs A to I. It's just making it clear it's going further than Section.
Yeah. Well,
first part of Section 2.
I think it's part of Section 2, isn't it? It's that first part of the preamble, although it plainly refers to potentially Section 2 authorised work.
Yes, but the first part of Section 2.
Yes.
Yeah, I think we're saying the same thing.
Yes, I think we are. Little b, for the purposes of or in connection with trains, or all part of whose journey is on Phase 1. That is simply a reference to the running of trains up and down the track when it's built, or the operation, if you like, of the railway. So it's not relevant here, and it's not relied on. Little c is relied on, and it says otherwise, so that's not dealing with the first two things, for the purposes of or in connection with Phase 1 of High Speed 2, or any high-speed railway transport system of which Phase 1 of High Speed 2 forms or is to form part. So sadly, that takes us back to Section 1. I say sadly because it's a bit of a convoluted way to understand what should be relatively straightforward in making sense of Section 2. And we see that in Section 1, little 3, Phase 1 of High Speed 2 means a railway between Euston and Birmingham. And Phase 1 of High Speed 2 is referred to as the key element that I've already referred to in Section 1, little a, that first category of work that's governed by Section 1 and Schedule 1. So, trying to make sense of those references, it's our submission that this subsection 2, little c, read in context, makes it clear, that's its purpose, that what is permitted refers either to the Phase 1 scheme as built or another high-speed railway system of which it's part or is to form part.
So you're looking at C now?
Yes.
And you added the words as built?
Yes. In order to make sense of that, and in context, we've got the first part, reference to authorisation under the Act. And that, as your Lordship rightly indicated, might be a reference to Section 1 or Section 2, and doesn't really add much, and is therefore obviously not relied upon, and doesn't help with the interpretation of the preamble in Section 2. Little c is relied upon, and that's something different. And it goes beyond little b, something different from the operation of the trains, but in that context, it's our submission that this is referring to a future proofing, if you like. It's looking to that first category of works in Section 1, the railway itself, when it's actually permitted and built, whether it be on its own or as another high-speed railway system.
Do we see any words that suggest that it's limited to Phase 1 as built?
Not in express terms. I readily accept that I'm trying, I hope to make sense of it. To interpret it in any other way leads to far more difficulties, because in effect it would be the tail wagging the dog, and that is the essential impasse between our case and that of the respondents and the interested party, because they interpret this as being, well, what you can't do if it's ancillary or incidental to in the first part of the preamble, you can cover because it's otherwise related to the purposes of something more general. And we say that that just doesn't make any sense of a statute which sets all this out and then says, but if you're not covered in anything above, you can do absolutely everything you want to do, even if it's to change the very key element of the work. And the only way we say to make sense of it is to say it's about future-proofing, not to the construction stage, but to when the railway is approved, built, and in existence. And here, of course, the extension is not permitted. It's not built, and it's not yet in operation. And we say it cannot reasonably have been Parliament's intention that the extension of the Bromford Tunnel could be properly regarded as for the purposes of the Phase 1 railway, which after all is that first category. It is the railway itself, which as things stand now is to be defined by reference to the currently authorised works. Again, just standing back, remember that Section 2 is about other works, but reliance on this section to justify a change to the scheduled works means that Section 2 is being used actually to override Section 1 and to do something different. That's not what Section 2 is about, in my respectful submission.
It's not so much overriding, there is a power to carry out a particular work specified in the schedule. The power doesn't have to be exercised. It's not a mandatory obligation to exercise that power. So if on the respondent's interpretation this does authorise some different form for part of the route, it would be something not overriding that provision, but providing an additional power, an alternative power, if you like.
But it doesn't stop there, because the invitation here and the learned judge's conclusion was that the extension was authorised by Section 2. Here, this subsection. But the effect of that is to override Section 1 and Schedule 1, because it's providing for something in a very different way from the mandatory instruction that's provided for in the text.
If that interpretation is correct, it isn't the end of the analysis, because obviously you've then got to go through Section 20 to see whether you have the benefit of a deemed planning permission, and that brings in the environmental protection.
But only the environmental things, and the public are excluded. HS2 make their own decision about whether an environmental assessment is required. The petitioners have no chance to look at it. But it cuts across all the submissions I've made about the detail and the scrutiny given by Parliament to Schedule 1 works. And what I say is the common sense, practical understanding of Section 2, which is to accommodate those works, not to change them. It would be to turn the statute on its head, I think.
Sorry to interrupt.
Not at all.
It's a question I usually ask at about 1:45. When do you think you'll be in a position to hand on the baton to Miss Ollie for Ground 2?
Not before lunch.
Well, yes. Not before lunch, but could it be at lunchtime?
I will endeavour to finish by 1 o'clock. If not, I will seek to finish within 15 minutes beyond that.
See how we get.
Yeah.
Right.
Yeah. And here, my lord, the fundamental point which drives through the learned judge's judgment is that if the tunnel is not consented the portal has nothing with which to be ancillary to, or connected to, or for the purposes of. It's merely a concept.
You said consented. Did
Yeah.
you mean authorised?
Yes, I do. You're quite right. You're quite
You
absolutely
didn't
right.
have the section.
Yeah, because then you're
Yeah.
absolutely right. Turn to section 20, and I've indicated the restrictions on that part of the process. Now, we need also to look at the, turning to the lady's focus on little I, but it's worth also just looking more quickly through the other items. And we say that when you do that, the ancillary nature of these works, or the accommodation nature, they very much read as a list of things to be done to accommodate or facilitate the construction of the railway or its operation. They're all different from the authorised works under Schedule 1. So the first is electrification. B and C, these might be thought to be things that were that might be needed or expedient, but not foreseen in order to accommodate the works. But focusing on the phrase maybe necessary or expedient, that begs the question, necessary or expedient to what? Well, in my submission, it's necessary or expedient in order to provide for the principal works which are governed by Section 1 and Schedule 1. And of course, there's no reference to any tunnel or viaduct, and that's because, as I sought to emphasise, the construction formation of the railway in those two respects is addressed and fixed in Section 1. D to H, these are works which are done to prepare for the scheme, to receive it or accommodate it, and again, something other than the scheme itself. Little I, such other works now, which is the focus of the learned friends, of whatever description, as may be necessary or expedient. Again, the question, well, necessary or expedient to what? In my submission, it's to the principal works authorised under Section 1. It's to, it's a plainly not to be used to change those works. A glance only at subsection 2 perhaps shows some context as to what's being looked at here. Subsection 1, that's the whole of it, doesn't authorise the making of any cut for drainage purposes which is more than 3.4 metres wide at the bottom. Well, I appreciate that's quite an isolated point, but as Miss Levy asks, rhetorically I suppose, is that it seems to mean on the Secretary of State's interpretation that it wouldn't be possible to make a cut beyond 3.4 metres wide, but one could extend a tunnel by approximately 3 kilometres. That, to our understanding, would not make sense of this provision. So the court does have to decide whether or not this subsection is to be interpreted in line with the rest of section 1A to H, which we say on any sensible view it works of an ancillary or incidental nature, or whether it considers it's a provision to allow for any change, even one to change the nature of the primary works of the railway formation itself, and obviously goes well beyond something that could be ancillary or for the purposes of those works. In our skeleton we use the phrase "justum generis," and what we mean by that is that little paragraph I has to be looked at in the same genus. And the genus here is that these works must be works other than Schedule 1 works, and must be works to accommodate those works, or supplementary actions to facilitate the principal works, and in particular the railway, as it is defined in Schedule 1. The words, whatever their description, doesn't take away or negate that principle. Maxims, I appreciate and readily acknowledge, are not always as helpful as they might be intended to be. But here it's not the sole argument. It doesn't end there, as we also say that little I is plainly a tail-end piece. That Parliament cannot have intended to cover works more substantial or more wholesale than the matters that have gone before. In any event, it can't be treated as one to allow important infrastructure to change because it could somehow be denoted as ancillary. And that's particularly important when it's referable to the primary works. Going back, and this is my fourth main submission in relation to Section 2, tunnels and viaducts are not included. There's no power in Section 2 for these. There's no reference to either type of development. On its face, the power doesn't extend to these. If they had been considered as potentially relevant to Section 2, Parliament would surely have included them. I mean, it can't be said that Parliament has somehow, well, we've forgotten about tunnels and viaducts, when they're mentioned so many times as an important critical aspect of Section 1. So our interpretation does make sense of the framework of the Act and the approach of Parliament to specifically approve tunnels and viaducts as an integral part of the railway covered in the schedule. One only has to sort of stand back and look at the way the inspector addressed this argument. And do you remember he said, well, they're meant to be tunnels, Parliament would have said so. But the Secretary of State's interpretation is far too generous and would appear to give a carte blanche. Now, my Lord has pointed out, well, that's not the end of the story, so it can't be regarded as carte blanche. But yes, but it cuts out an important part of the process because it's taking the place of Schedule 1, assuming or purporting it to be a Section 2 ancillary work, and then it's tested at the EIA, but excluding the parliamentary stage, nothing what Parliament settled, quite different and quite substantial by any measure. So I turn lastly to the Secretary of State's interpretation, just to make a few additional comments, and I think it would be helpful to look at the case of Edison in the authorities bundle. Tab 11. And this is in response to the response from the Secretaries of State about Parliament's intention. And if I could ask the Court to read 116 and 117. And in particular, the first part of 117, which doesn't feature in my learned friend's skeleton argument, but actually is important. And we say that the Secretary of State's interpretation would mean the following, would flow, and plainly not, we say, something that Parliament could reasonably have intended. First, the reach of Section 2, little Roman 1, would be found to extend, that should be, well beyond works that are properly ancillary. 2, it would make most, if not all, of section 2, which goes before, redundant, because it would be said everything is covered. 3, it would have the effect of authorising alterations to the scheduled works when no such power exists or is said to exist and no amendment has been made to the schedule. In this case, fourthly, it would mean that section 2 could be used to authorise the tunnel extension scheme even where this would conflict significantly with the scheduled works and where the scheme was not before Parliament. Fifthly, the Court will also have in mind the effect of section 20 to deem planning permission for section 1 works. It's trite law that the description of development can't be altered by conditions, but that is the effect of the argument put on the other side. It's exactly what is being proposed in this case. The description, specific as it is in effect being changed or overridden. Sixthly,
By conditions.
By the process under section 20, which would lead to a Schedule 17 consideration.
Well, before you get to Schedule 17, there's just the question of interpretation of Section 20 as to whether the defined development has the benefit of deemed planning permission. But that's not changing the description by a condition.
No, but if you're doing something that is otherwise covered in Section 1, the construction of the railway, and Section 2, you're qualifying it by reference to the environmental impact questions. But in effect, you've sort of bypassed that first stage that Parliament was so careful to settle.
Sorry, I interrupted you. We're about to get to 6.
6. As a result of the judgment, there remains inconsistency between Schedule 1 and what's said to be authorised under Section 2. Indeed, it would leave Schedule 1 as it is, even though the scheme as built would be very different. As I've said, this is the 8th point, it would mean that those specifically affected by a significant change would have been denied the opportunity to petition in front of the relevant committee on the impacts, as I've said already. 9thly, the stages in Parliament were all conducted on the basis of the scheme as settled and as set out in Schedule 1, a scheme that was scrutinised carefully. This scheme is a very different scheme. It's accepted that the scheme is not one of final design, but the detailed design is to be dealt with in Schedule 17. A point then also to remind your Lordship of the environmental statement expressly excluding the change that is now sought to be covered by Section 2. And what it would leave is for the extension to be covered only through Section 20, where of course HS2 are judge and jury in terms of the relevant question. It can't be said, as it is said, well, it would lead to all sorts of impracticalities. Actually, it wouldn't. Our interpretation is correct. It has to be remembered that the Act was drawn up in the knowledge that it might not cover everything and that other powers might be necessary. And with that in mind, it's helpful, I think, lastly, if I may, look to the supplementary bundle at page 115 This is in the Environmental Minimum Requirements Annex 2 Planning Memorandum. And you'll see the section 8. There may be instances, I'll leave the court just to look at those 2 paragraphs.
Yes.
And also at tab 10 on page 97,
So the references.
tab 10, page 97, this is in another of the Environmental Minimum Requirements General Principles document. The controls in the EMRs, I'm looking at paragraph 1.1.3. And the aim, it is said, is to ensure that impacts which have been assessed will not be exceeded. And then there's an unless clause. New impact or impacts in excess of those assessed in the ES, 1, result from a change in circumstances, not likely at the time. Pausing there, of course the extension to the tunnel was expressly excluded, would not be likely to be environmentally significant, or results from a change or extension to the project, where that change does not itself require environmental impact assessment, and lastly would be considered as part of a separate consent process, and therefore further EIA if required. So what is built into the understanding of the Act is that it may not cover everything, and there may be reasons to have a different process, which of course, a gentle reminder, is exactly what HS2's first position was. And my Lords, I've strayed 5 minutes into the luncheon adjournment, which apologies, but subject to any afterthought, that completes my submissions on ground 1.
Right. 2:05 then.
What lies available?